inviting me and for coming to hear me. The pink background obviously is for the ladies in the cases. So first of all, let me introduce the project where I obtained the cases from. They were all selected from a database designed for a forthcoming project titled Islamic Court Cases from the Arab World at the American University in Cairo, comprising of 7,000 cases, give or take, managed by Dr. Muhammad Sirag, who was my former supervisor during my master's, and Dr. Wafia Hamouda, assistant at Tanta University, to which I have contributed as a translator. The database includes as yet unpublished archival material of cases listed in legal compendia, manuscripts, and the Egyptian National Archives, covering 4 periods: the early classical period, the pre-modern era, the 19th century and contemporary times. The cases fall into 4 areas of the law: torts, commercial law, criminal law, and family law. And at the bottom is the contact of the coordinator, Dr. Wafia Hamouda, who is with us today, in case you want to find out how to use the project. So some cases chosen will show the practical side of the law, or in other words, how the judges applied the law, regardless of what was written in the fiqh manuals, confirming that rulings often not only diverged from the theories enshrined in the inherited manuals, but also set precedents. And most importantly, the cases show that certain theoretical aspects or concepts were not applied in the real world of the lived reality. Historians did not just objectively write history as it happened, as we all know, but many other contexts influenced their choices of what to record and how to record. They were perhaps following orders of rulers, occupiers, or colonial powers in exchange for positions or whatever, or were inclined to record or ignore certain things because of their own ideological or sectarian leanings. Therefore, in modern times, new concepts emerged like history from below, which gives voices to those who were marginalized, written out of history, ignored, and remained voiceless. And this project here, as I will show with my own cases, offers a new historical reading that I like to call history from within, because it shows how the community was through the real cases in real time and the issues that were taken to court and by whom and so on. I will hopefully present 7 cases from Egyptian court records with a chosen focus on Christian women, either as plaintiffs, defendants, or subject matter, showing that Christian women were regarded as legal entities. They knew their rights, filed their own cases, in spite of the legal manuals saying that a woman cannot file a case, it has to be her guardian. They were held liable, acquitted, or received their dues regardless of their faith. Women's testimonies were accepted in court, despite of the theoretical aspect outlined in Islamic legal manuals regarding women's testimony in general and the testimony of Christians against Muslims. With regard to women, opinions of course range from completely rejecting female testimony in certain legal areas to conditionally accepting it or requiring a supporting male testimony to accepting women's testimony altogether. So women were disadvantaged in many aspects of theoretical rules regarding testimony, and Christian women more so, but we will see the opposite in those cases. In the fiqh manuals, the jurists regulated almost everything based on an implicit hierarchy, where Islam trumped all other religions. Men were above women, free persons were above the enslaved, and so on. And theories were based on these implicit hierarchies, but we don't find them in these cases. The cases offer insights into the discrepancy between formality and rigidity of written theoretical legal manuals and the lived reality contesting certain stereotypes. So now let us look at the first case. The case is from 1655, and it was tried in front of the court of Misr al-Qadima and has number 102 in the register. So the case was filed by a woman, Babara bint Yusuf, of the house of Barsum al-Fashin, against her husband, Girgis ibn Mikhail al-Nasrani al-Yaqubi. So they're both Christians. for the payment of her deferred dowry, as well as all her other outstanding rights. Her husband attested in front of the Hanafi legal judge, who remains unnamed in the document, that he had set the dowry for his fiancée at 30 and a half halves of silver, equaling 11 piastres. She had received 8 piastres already, he admitted, and she was still due 3 piastres. Her father brought witnesses to the court who testified to this, namely Habib ibn Yohanna, Jirjish ibn Nusayr, and Yaqub ibn Ayyub, all teachers and all dhimmis or Christians, as dhimmis is the label used in the document. The legal judge and the husband accepted the testimony of these 3 witnesses, that in addition to the dowry, the husband had to have provided clothing for his wife, namely twice a year in winter and in summer, which has to be suitable and comparable to that provided for her peers. The husband had included that in the marriage contract at the time of the marriage. The judge ruled that the contract was valid and accordingly legitimate and has to be fulfilled, and the husband accepted that. So as we can see here, the case is only about establishing a wife's right to what is due to her, so her dowry and her clothing and all that. The husband needs to pay this amount or find a legal way out of this commitment. Interestingly, the marriage contract and the conditions in that contract mirror Muslim marriage contracts that oblige the husband to pay dowry and maintenance to the wife in terms of clothes, housing, and food. The wife did not ask for a divorce. She just asked for her rights, and that judge obliged. And the dowry can be divided into 2 parts, and usually is a part paid upfront at the time of the marriage contract, and the second part is to be paid later. But until it is paid, it is considered a debt. And in Barbara's case here, she called in that debt. So the second case is from 1668, so 30 years later, and it is also in front of the same court, Masr al-Qadima. And the case was filed by Ghattas ibn Tumas ibn Abshay against his son-in-law, the Zimmi Salib ibn Matrus al-Nasrani al-Yaqubi, also in front of a Hanafi legal judge. The plaintiff explained that the defendant married his daughter Nama and claimed that he is no longer able to consummate marital relations with his wife as she has become nashes. Now, this is an interesting word, and it means disobedient, kind of. So according to legal texts, Muslim legal texts, if a wife leaves the conjugal home without a sound reason and refuses to return, she is nashes, and therefore she has to forfeit her right to maintenance. Now, dragging the wife back to the matrimonial home, according to James Anderson, is pure Sharia, and it refers to verse 434, which permits a husband to use force against his nashes or disobedient wife. However, enforced obedience only became part of the state law in Egypt in modern times and was not even on the horizon in 1668. The husband asked that she be returned to him and to her house and to be obedient to him. The wording is almost verbatim of the modern institution called Bayt al-Ta'a, literally house of obedience. It's the institution of forcing a wife who has left her husband's house and therefore is considered nashes to return to it. According to Article 93 of the 1897 Egyptian Ordinance against the Sharia courts, organizing the Sharia courts, and the equivalent 1931 law, Articles 345 and 6, a husband who has been granted an obedience decree by court may seek the assistance of the police in forcing his rebellious wife to return home. The Egyptian government thankfully abolished this horrible institution of Bayt al-Ta'a in 1967. So this husband's demands come 300 years too early. In any case, the husband was asked and confessed that he did not pay up his outstanding dowry, and that his wife still deserved money from him, equivalent to 202 halves of silver amounting to about 5 piastres, in addition to the price of a bag of wool that she paid for, as well as the rest of her clothing and maintenance from the time he consummated the marriage. So basically, she ran away because he was withholding her rights. So when the judge added everything up, it amounted to 51 halves over and above what is due to him, namely 42 silver halves, which she had loaned him. She attested to all of that and stated that her father had repaid the loan already. Namely, one, he didn't pay it in monetary terms. He gave him an irdab of wheat. So irdab is a measure of weight that is basically around 73 kilograms and refers to wheat that is free from dirt and husks, so pure wheat. However, the defendant did not ratify that, and therefore his wife asked to swear a legal oath. And when she was granted the permission, she swore, and the judge ordered the husband to pay the entirety of the outstanding amounts to Nama. And this means that he took her word for it. And the husband needed to pay her all what is legally due to her. After that, the judge ordered her father, once that her husband paid up, to make sure that the daughter is returned to her husband, who must live with, and she must live with him and house her in a proper place that is legally suitable to be a place of obedience. So the interesting thing about this case is that all those involved, whether plaintiffs or defendants or witnesses, are Christian, and each of them asked the Hanafi legal judge to rule according to the Sharia and based on Islamic practices like marriage contract, obedience, and so on, to which, of course, the judge obliged. And even more interesting is that the entire case rests on fiqhi definition of marriage, a contract where the husband pays the wife the dowry in return for availability and legal sex. So the third case is slightly earlier, from 1583, but there is a reason for this order. And it was filed by a woman, namely Sukkar bint Shakir ibn Abdullah al-Nasraniya. She asked her husband, Mina ibn Salama ibn Jirjis, the jeweler, for a single divorce and agreed to free him from the deferred dowry he is still owed to her, as documented in their marriage contract. He obliged and divorced her after they both had admitted that the marriage had been consummated and attested, both of them, that they came to court willingly out of their own free will, that they are both healthy and in perfect control of their mental faculties, and they agreed to exonerate one another of all the resulting responsibilities, and that there were no outstanding dues. And then it's cute how the document refers to the outstanding dues. It says, no claim, no gold, no silver, no copper, no alimony or any maintenance payment, no outstanding obligations, big and small. So they both fulfilled all legal conditions and duties to date, and the judge granted a khula to Sukkar. Now, khula is a purely Islamic system according to which the wife ransoms herself by returning the dowry or the advance on the dowry paid to her and waives all her outstanding rights in return for divorce. According to the majority of the jurists, this is an irrevocable divorce. So the husband cannot take her back within the waiting period, usually 30 months, 3 menstrual cycles. So according to the Coptic Church, neither divorce nor khula are recognized, as the spouses become one before God and are no longer two persons. Therefore, a khula is actually a blatant violation of the essence and core of Coptic teachings about marriage. In general, Christians can obtain a civil divorce in courts, but then that needs to be approved by the church, which only happens in very, very rare cases. If the church does not approve the divorce or the khula, it considers the spouses still married but physically apart, and none of them is allowed to marry. Otherwise, this becomes adultery and they are excommunicated. So valid divorce in the Coptic Church is only allowed when there is a difference of sect, or proof of adultery, or a long separation amounting to a certain number of years, usually the minimum is 7, and the courts do not recognize a Christian change of sect unless an official certificate is issued by the religious authority that this person joins. So in fiqh manuals, the application of the provisions of Islamic law on Christians or dhimmis and also on Jews depends on their own free will. Islamic law is the law of the state. Today, it is the constitution that makes it the main source of legislation. At the end, I will mention two very interesting modern cases that challenge all this. However, it is noted that it is permissible to apply Islamic law on what it is not permitted. It's not permissible. It's absolutely not allowed to apply Islamic law on what contradicts the essence of Christianity. So Sharia as a legal system is resorted to in cases where a dispute arises. And in modern times, any court shall not issue a khula except after trying to reconcile the spouses within a period not exceeding 3 months, even Christian couples. But the custody of a young child or the alimony payments are not forfeited in khula, so the wife receives them. So khula was not the only way Christian women ended their marriage, as we can see from the fourth case, which is from 1666, and it's from the Old Cairo Court. So Al-Zaini ibn Salib of the house of Al-Hadayda, Al-Nasrani al-Yaqubi, came to the Hanafi judge and declared that he is giving legal testimony without coercion and that he is ratifying the divorce that took place before this date to his dhimmi wife Sitt al-Dar, a mature adult woman, daughter of Yusuf ibn Yohanna. He also ratified the validity of all what she had asked for in terms of the dissolution of the marriage that was obtained through a ruling of this very same court in 1657, meaning 9 years prior to this date. He added that his former wife, Sitt al-Dar, has been divorced by a single divorce. We've heard that term before, and it's interesting, but we will talk about this at the end of this case. And he also attested to having consummated the marriage legally, meaning it is a divorce and not an annulment. Both declared that nobody owes anything to the other, that there are no liabilities and no dues. Again, we have the same phrase, no claims, no silver, no gold, no money, no copper. But here he adds no textiles and no mota. Now, mota, we will pick this term up also because it's very interesting. And nothing small nor negligible that was still outstanding, and they both attested to that. This happened in the presence of another dhimmi woman, Mubaraka, daughter of Mirham, who testified that her divorced daughter, Sitt al-Dar, has no dues forthcoming to her from her ex-husband. The judge attested that the divorcee Sitt al-Dar was identified by the testimony of a number of witnesses, all Christian, and that the divorce that had taken place is legitimate and satisfactory, and he confirmed it as legal. So why they both went to court is not mentioned, since nothing was disputed or demanded or anything. They just ratified a divorce that took place 9 years earlier. So maybe they were intending to get married again, and since 9 years is more than 7, one of them got a permission from church or something, so they needed the documents. I really don't know. Anybody's guess is as good as mine in this case. So now we go back to the two terms, first single divorce and then muta. So single divorce comes from the restriction of the divorce between a couple to 3 times, as the Quran limited the number to 3 divorces, after which the man cannot take his wife back. Before Islam, men kept their wives in a state of uncertainty or kind of limbo by continuously divorcing them and taking them back at will over and over again. So the Quran put an end to this, and verses 229 to 30 limit the number of repudiations that a man may pronounce against his wife to 3, which she becomes unlawful to him, meaning that he cannot take her back. This can be remedied only by marrying someone else. And this intermediate marriage is called tahleel marriage. And it's a practice in which a woman, after being divorced thrice or by a triple talaq, which is mainly practiced in Southeast Asia now, marries another man, consummates the marriage, and gets divorced again. Now, the triple talaq is 3 divorces in one sitting. and it's been regarded as not permissible. However, this tahleel marriage is considered reprehensible since the object of marriage is to create a lasting relationship and not be just a trick to circumvent the 3 divorces rule. So the majority of jurists held that a divorce in general without a compelling reason was reprehensible, makruh, should be exercised sparingly and completely avoided if possible. So kind of echoes the Christian idea or the Catholic idea and the Coptic idea of marriage. As for the second term, mut'a, it literally means enjoyment. It has also been used to denote a temporary marriage or a marriage of pleasure that is contracted for a fixed or defined period. In the Quran, there is a reference to this form of marriage in verse 424, although the Orthodox exegesis of this passage refers it to the ordinary marriage. The verse first lists the women with whom contracting a marriage is forbidden. It then goes on to say, and further you are permitted to seek out wives with your wealth in modest conduct, but not in fornication, but give them their reward for what you have enjoyed of them. Istamta'tum. So it should be noted that mut'a is also used in Islamic law in quite a different sense, namely to denote an indemnity payable to a divorced wife, which is the meaning used in this court case. And it is called nafaqat al-mut'a and is based on 2 verses in the Quran, 236 and 241. It is usually, the amount of it is usually decided by the judge and assessed based on the length of the marriage and type of divorce. So the divorcee should receive quite a few payments at the time of divorce, namely the deferred dowry, nafaqat al-mut'a, nafaqat al-idda, idda is the waiting period, alimony or payment in case she has young children, a sort of breastfeeding fee if she's nursing based on another verse, 65:6, and she also gets custody of the children. So again, the interesting case about this, the interesting thing about this case is that all involved are Christians. Also that the husband uses expressions and concepts purely based on Islamic practices, marriage contract, single divorce, mut'a, etc. And again, like in the second case, it is very interesting that the entire case rests on the fiqhi definition of marriage. The fifth case is a bit later, from 1776, and it is the quote of Al-Bab al-Ali. In this case, the Zimmi woman Maryam, a Christian, brought a lawsuit against the maternal grandmother of her son's children. Maryam claimed that her daughter-in-law, the mother of her son's teenage daughters, we know that they are teenagers because the term used is murahiqatain, so they are anything between 11 and 16, had died, and that her mother, the girl's other grandmother, had taken custody of the 2 girls. She said that she, as the father's mother, has priority of custody. She was willing to provide it free of charge without collecting a custody wage. She asked the Hanafi judge to force the maternal grandmother to hand over the girls. Since according to Islamic law, she had right to custody. The maternal grandmother acknowledged that she used to receive payments from the father, termed as ujrat hadana, literally payment for custody, adding that their father was well off and could afford it. However, she said she was willing to care for the children without any payment at all. In this case, she would have priority of custody. So the judge told Maryam that if the father no longer paid the maternal grandmother for her care, the maternal grandmother indeed had priority of custody, and he dismissed the case. However, the judge also decided that the father should pay 120 silver pieces a month to the maternal grandmother as maintenance of the children, justifying his decision, saying that the father was well off and could afford it as per his own mother's testimony. So while the document does not tell us the amount of the previous maintenance prior to this lawsuit, it is clear that the stated amount was unusually high or even higher than what was collected before. The judge probably compensated the maternal grandmother for the loss of her custody fees with an increase in the nafaqah allocated to the children. Perhaps the judge did not want the 2 girls to suffer from any decrease in income resulting from this lawsuit. one cannot but think that this decision was motivated by a concern about the well-being of the children and their care provider, whose suitability as a caregiver was never challenged by anyone. The preference of maternal grandmothers as custodians is based on Islamic law. The document only explicitly mentions that Maryam was Christian and does not say anything about the religion of the father or anyone else. So the assumption here would be that they are all Christian, but interfaith marriage was common, and the Ottoman court records until the contemporary period contain cases in which Egyptian Christians, especially women, converted to Islam to create a situation in which the other party lost custody. In one set of Cairo records from one court in 1837, there were 6 cases of conversion to Islam from Christianity and Judaism, 4 Christian women, 1 Christian man, and 1 Jewish man. One very old case mentioned in the fiqh manuals and is taken as precedent from the 5th century or 11th century, discusses the case of 2 Muslim girls whose Christian mother had died and was survived by her own mother, the Christian grandmother of the 2 girls. And the judge ruled that the girl should be given in custody to the Christian maternal grandmother, as she is more deserving of their custody than the paternal grandmother, even if the paternal grandmother was a Muslim. So in principle, the wife obtains custody of the children while the father retains guardianship, that is the authority to take important decisions involving them. This means that the children live with their mother until custody ends or until someone else obtains the custody for some reason. At the age at which custody ends differs according to different schools of law. So for the Malki, it ends at puberty for boys and at marriage age for girls, which is interesting since the marriage age for girls is disputed in Islamic law itself, but we will not split hairs. The Hanafis ended at age 7 for boys and puberty for girls. The Shafi'is opine that custody lasts until the children have reached the age of discretion or rushd, which is also disputed. For the Hanbalis, custody ends at 7 for all, and for the Shia, custody ends at 2 years for boys and 7 for girls. In all schools, the rule is that when custody ends, the children should live with their father. If the woman remarries before the children have reached these stipulated ages, custody rights transfer to her mother or any other female relative. Also, the father's mother is there. Shia and Shafi'i deny custody altogether to the mother if she is not Kitabiyya, meaning the mother has to be either non-Christian or a Jew. Otherwise, she will lose the children. The 6th case is from 1860. It's a Muslim woman made a claim against a Coptic woman in front of the Giza court. So the claimant said that she had a wart on her upper eyelid, and she had heard that the defendant was a healer and therefore went to visit her and have the wart removed. The defendant brought 2 small pieces of reed and tied them together, trapping the portion of the plaintiff's eyelid, the wart, between them, telling her that after a few days, the bit which was tied off would dry, atrophy, and fall off on its own. After the defendant after the plaintiff left, she went home, and her eye began to swell, accompanied by severe pain. After 12 days, so she says in court, after 12 days, she visited the defendant again, who examined her and told her that her eye was severely infected and damaged and that it had now become blind. She further denied being at fault, since tying up a portion of the lid would not cause such an inflammation. The patient left and bad-mouthed the healer everywhere and then went to court asking for compensation. So we have a kind of a playback in the court document about what had happened prior to the court case. So the judge calls for a physician from the government hospital who examines the plaintiff's eye and tells her and the court that it was still severely inflamed and was completely blind, and but not because of what the defendant had done, but because the claimant had gone home and put a poultice of whole wheat bread on her eye, which caused the inflammation in the first place and the subsequent infection. So this she did on her out of her own accord, and not based on any advised by the defendant. The court ruled that the eyelid was tied by the Coptic healer with the permission of the plaintiff. It was in line with customary treatment of such cases, and that the defendant is not liable and did no wrong, so the case was dismissed. So the case reveals a great deal of information, and not only that women were assuming certain professions and practicing them, but also that members of religious minorities were not treated any differently in front of the law or at court, especially when accused by a Muslim. They were acquitted and not discriminated against based on their faith. Most importantly, their testimony was accepted even against a Muslim, as this case showed. Sadly, the court case does not show us whether or not the healer asked for a compensation from the Muslim woman for damaging her reputation because she badmouthed her, which is written in the court document. So while legal doctrines and theories do not consider non-Muslims equal to Muslims, placing prohibitions and restrictions on their testimony against Muslims, the actual treatment of non-Muslims, in this case, the Coptic woman in court, suggests fairness and justice, regardless of her faith, and underscores ethical norms. Such cases remain understudied. And furthermore, there was an expert witness who was consulted, in this case, the physician from the government hospital, which is another area which also remains understudied. So in some fiqh manuals, the testimony of an unbeliever is defined as is not acceptable. And the unbeliever is defined as someone who does not believe in Islam. And therefore it's not acceptable. His testimony is not acceptable, neither against a Muslim or even against another unbeliever. If he was an unbeliever and converted to Islam, his testimony becomes accepted in what only refers to the time when he was, when he became Muslim. So, for example, in Al-Hidayah by Burhanuddin al-Marghinani, we find a ruling that dhimmis, Christians and Jews, may testify concerning each other, and that their testimony with respect to each other is admissible, notwithstanding that they be of different religions. Malik and Ash-Shafi'i, the author reminds the reader, have opined that their evidence is absolutely inadmissible because as unbelievers, they are by default unjust. And fiqh argues this using verse 49:6. So if a disobedient one comes to you with information, this is the part that they use. So therefore they argue that a jurist has to be very, very slow, tarawi, in believing anything such unbelievers may advance and not admit any evidence against a Muslim believer. So while a dhimmi does not possess power against the Muslim, he possesses power over himself and over his family. But in this case, as we have seen, the judge accepted the testimony of the Coptic healer and even consulted an expert witness who corroborated the testimony against a Muslim woman. The final case is much later and is from 1910, but I chose it because it relates to a topic that was discussed a few seminars ago, namely missionary work. And also because this case had an afterlife that stretched all the way forward to 1942. The case was filed at Naga Hammadi Sharia Court to legalize a waqf, an endowment, that was established by Dawood Bey and his wife. The waqf covered 1,009 fiddans and some fractions, as indicated by the deed, and included all buildings and plants on the land. Faddan is an Egyptian unit of area equal to about 1,038 acres. Dawood Bey and his wife, both Christians, established the waqf for the duration of their natural lives, each contributing to it. They stipulated that after the death of one of them, the proceeds of their endowment will be spent in full by the one remaining for the duration of his or her life, and that their descendants had no right to the proceeds or the endowment. After their demise, the proceeds should be spent according to a list that they created, and the beneficiaries are defined. So the first beneficiary is the Mashiach Church, which is the Evangelical Presbyterian Church in Egypt, in Bahjura, but it has a condition: as long as it is affiliated with the General Mashiach United Church. The second beneficiary is the Synod of the Nile of the above mentioned church, which became autonomous in 1926 and an officially independent church in 1958. It helps with running hospitals, clinics, social services, and so on. Third, those who have retired from working Synod of the Nile, meaning ministers, priests, and missionaries, provided that their retirement is due to disability or illness that prevents them from carrying out their missionary work. Fourth, missionary work. And here we have the point of contention. Preaching the gospel in Egyptian lands as well as in the Sudan, provided that it is through the Synod of the Nile. Fifth, distribution of the Holy Book through the Society of the Presbyterian Church, Evangelical Church. And sixth, the infirm, handicapped, orphans, and widows of Bahjura, including Protestant and Orthodox members, so all Christians. However, it is stipulated that each of these should be without earnings. Now, point 4 is the interesting point here, namely missionary work, but we will get back to this later. The couple further stipulated that the Waqf proceeds shall be spent equally on all these 6 beneficiaries. They had some sort of other conditions, 10, but they're not detailed in the document, and some of them don't interest us. However, anyhow, the legal deed was issued on September 22nd in 1910 from the aforementioned court. The case becomes dormant for 2 decades until on October 8th, 1931, the wife goes to the Sharia court of Alexandria and changes some of the conditions and adds a beneficiary. From the second document, we learn that the Waqf comprised of 633 faddans, 23 qirat equal to 170 square meters, 15 sahm equal to 7.2 square meters belonging to Dawood Taklabi, the husband, and the rest, namely 375 faddans and 10 sahm belonging to his wife, the adult woman, Palestine. The document does not say why she changes the conditions or whether her husband is now deceased or not. It just says that she came alone. She adds a 7th beneficiary and allocates 93 faddans and 3/4 of a faddan as a waqf for that beneficiary, namely a school that she and her husband had founded and built for the education of boys and girls in Bahgura. Now, the judge sends a request to Dar al-Ifta, asking about the legal ruling about the endowment for these 6 beneficiaries mentioned in the first deed, and also the new one, the new beneficiary, and about whether such an endowment is considered a valid legal endowment or not, especially since there is no evidence thereof in the first deed. So what we know is they established the waqf and nobody asked any questions and things were fine. It's only after that questions started emerging. So he further asks if the endowment is valid and in which points, and in all or only some of these conditions, and then what the ruling is for the invalid parts. So he receives an answer, and both his question and the answer are attached to the endowment deed. The answer is based on a fatwa dating to February 1936 in a different case, but similar, by Mufti Abdul Majid Salim, so we know his name. And it quotes, if a dhimmi makes an endowment on condition that this is an act of devotion, like making this endowment subject to distribution to the poor and needy of his own religion, or to the poor and needy from any other faith, then it is legal, as the poor and needy are found in all religions. And it is absolutely obligatory for everybody from all religions to be charitable to the poor and needy, according to verse 2:195. However, if the endowment is based on some form of exclusive charity, like for example, the endowment to the 2 holy mosques, or an endowment for monks, priests, and missionaries, meaning that this charitable avenue only exists in one religion and not in the other, then this endowment is invalid, meaning that it is incorrect to make this type of recipient a beneficiary. Therefore, if it is invalid, therefore it is invalid to designate priests and missionaries as beneficiaries. It is also illegal to spend on them, but charitable spending should rather be spent on those other than them, from amongst the poor, the needy, and the orphans of any faith. Then the answer further elaborates on this by quoting Hanafi jurist and traditionist and so on and so forth, and ends with, when the charity, what Muslims spend in charity for God and what they may spend in charity for God is all charity for God. The ruling was then based on this fatwa that the endowment for the first, second, fourth, and fifth beneficiaries, here noted in red, is incorrect and invalid, and that these beneficiaries should not be receiving the yield. And the yield should be spent on the poor and needy with regard to the husband's share of the endowment based on the original endowment deed. As for the endowment to the third and sixth, it is valid and allowed because the ministers, priests, and so on have retired. So they are no longer actively missionarizing and so on. And they are disabled and needy, because the endowment founders mentioned that they are poor, ill, and disabled from amongst them, just as they mentioned in the sixth stipulation, the poor and orphans and the elderly. Hence, the amounts set for them are valid, and each shall be spent in what they have endowed. Now, for the school, it is okay, because the school teaches everybody on one hand, and it also teaches different disciplines, not just religion, as it teaches handicrafts, sciences, housework, and so on, like any other public school following the Ministry of Education. So what is interesting here is that for 20 years, nobody asked any questions. Nobody demanded fatwas with regard to this endowment, but only when the wife went to add a beneficiary, the whole issue was studied again, and the waqf was then restricted based on 4 principles. That endowment by idhimmi is conditional on being equivalent to an endowment of a Muslim in order for it to be valid. 2, that idhimmi's endowment restricted for the purposes only available to Muslims, such as endowment for the 2 holy mosques, or for purposes only available to dhimmis, such as a waqf for priests, monks, and missionaries, is invalid in terms of its beneficiaries, and therefore should be directed to the poor, needy, and orphans. Interestingly, this contradicts something, because there was a waqf established by Bulus Hanna, a Copt, that paid for the education of Muslim students of Al-Azhar. So no Christian was admitted to Al-Azhar, to my knowledge, but I would love to be corrected on that. Anyhow, the third principle is that an endowment for the poor of a particular church is permissible, and the proceeds are to be spent on them, and the same applies for a will. And fourth, that the endowment to the evangelical school is permissible and valid. I know I talk too much, but I'm coming to an end. These cases, as well as other cases in the database, show that Christians and women were plaintiffs, defendants, and witnesses. And as of 1933, there were also women lawyers. The first female lawyer in Egypt was Naima Al-Ayyubi. She studied law at Fuad First University starting in 1928 and was the only female student studying law. Today, women have made impressive gains as practicing lawyers, legal counselors, law professors, and judges. This has changed the legal profession, once dominated by men, even if in many countries, women judges are still clustered in family courts. There are some modern implications to all these cases that I presented. For example, in 2007, a Coptic lawyer, Mariam Raouf Ayed, submitted an appeal to the Supreme Administrative Court in Egypt against a ruling issued by the Administrative Court rejecting the papers she submitted to become a judge. She argued that Sharia does not prevent her from working in the judiciary, and there is no text in the constitution that differentiates between her and her Muslim female counterparts. Another Coptic lawyer, Huda Nasrallah, won a great victory for Christian women in Egypt in 2019, when she, after the death of her father, went to court demanding a share of the inheritance equal to her brothers and not based on Islamic law, where she only inherits half. She lost in the first court and in the second instance, but she kept on appealing, and when it ended in front of the Supreme Court, she won. So as a note, Egyptian criminal codes are based largely on European legal traditions, but Sharia is the guiding principle for family and personal issues. Now, allow me to end with a very amusing case, even though it doesn't involve a woman, but it's a Coptic lawyer who defended a Muslim youth in the case of insulting religion. So Makram Besha Abid, a famous lawyer and politician of the Wafd party, defended a young Muslim man accused of insulting the religion of a Copt, which was the first case ever of insulting religion in Egypt. So the Christian neighbor of the Muslim youth filed a lawsuit against him, accusing him of insulting his religion, and he brought Muslim witnesses and Christian witnesses who witnessed the incident. So Abid addressed the court saying that the young man was uneducated and only received some education in the village Kuteb, which is a type of village elementary school, memorizing the Quran, some hadith, the Prophet's sayings, and some rudimentary arithmetic. Abid explained to the judge that the children in the countryside learn in the Kuteb, Inna ad-dina 'indallahi al-Islam, meaning that God's chosen religion is Islam. So therefore, the young Muslim man did not really insult the religion of the young Copt because he doesn't even consider it a religion. He ended his defense there. Now the judge, it's been reported in the newspapers, the judge asked him, do you yourself believe in what you are arguing? So Makram Abid reported to have replied to the judge, Your Honor, I'm using what you believe in, since your holy book says in verse 109.6, you have your religion and I have mine. And the court broke out in laughter in its entirety at his response, and the judge acquitted the defendant. So it's worthy to note that the current Egyptian Penal Code punishes insulting religion or contempt of heavenly religions by imprisonment for a period no less than 6 months and no more than 5 years, and a fine no less than £500 and no more than 1,000. But sadly, this is usually only applied to someone insulting Islam. If I may add just one last case, very, very short, from 1858, in the presence of Muhammad Awais al-Hajiri and Mustafa Hamza al-Durra. They were both residents from Bani Suwaif. The Muslim woman Sitayta bint Awais accused the Zimmi Dawood Hanna that he quarreled with her and insulted her in public, calling her a prostitute and whatnot. And she demanded her legal rights according to Sharia, which means that she wanted him to be flogged, which was still done. The defendant was asked about that and he denied it. She was then asked to provide legal proof or any witnesses supporting her claim, but she failed and demanded she may swear the oath, but she was refused. So consequently, ta'zir was applied, which means ta'zir means punishment for offenses at the discretion of the judge. So he let the defendant go, no charges were demanded and nothing was paid in compensation, and she had to forgive him publicly. So that's the Muslim witness against the Christian, and she was dismissed. So thank you very much for listening, and I look forward to